Okay, we're back. Hello, everyone. I'm Tate with My Court Coach, and I have by my side Maria Kopian. How you doing, Maria?
I'm doing well. Hi, Tate. How are you?
I'm doing great. Thanks. So, as always, I want to remind you that anything you see here or hear here on this live stream is not legal advice. We are not your lawyers. We're not giving you legal advice on what you should be doing in your specific case, in your circumstances. To get legal advice, you're going to have to get a legal consultation with an attorney. Instead, what we're offering is just our input on how we've seen things happen, information, education. Also, remember, this is a public stream. So you're not going to want to share private information. You're not going to want to include your kids' names, things like that. And we're so happy to be back. As a reminder, My Court Coach is a program where you get coaching for your court case if you are representing yourself, if you don't have a lawyer. There are all sorts of good resources on mycourtcoach.com. For instance, if you have a California family law case, there are hundreds of videos and downloadable content, checklists, things that you can print out and bring with you to court that will be available to you for free at the California Family Law course at mycourtcoach.com. They're the videos that you see on YouTube, but they also include some downloadable content for a variety of the videos. On top of that, if you are presenting a case in court where you need to be presenting argument or evidence or testimony, documents, you're going to want help on how to do that. You'll get that at Full Court Preps. I do recommend you go to mycourtcoach.com to get the Full Court Preps to show you how to present a case in court. Okay, I think that's everything. Is that everything I need to share?
Yeah, it's all really valuable information and resources you have available for everyone.
Well, why don't you go ahead and introduce yourself, Maria?
Hi, everyone. My name is Maria Kopian, as Tate introduced initially. I'm a California family law attorney. I've been practicing for 6 years exclusively in family law. And I'm happy to be on this live stream and answer some of the questions we have in the comments in the threads.
Excellent, thanks. So what we're going to be doing today is we're going to be answering some questions that we've seen posted to various videos. And what we're going to start with today is a question about or a comment on this video here. Let's see if you can see it. Mm-hmm. Okay, here we have a question that says, this is on a video, get spousal support payments straight from your ex's paycheck regarding form FL 435. And the comment says, I have to fill this form out. Or maybe she's asking, do I have to fill this form out? I'm only asking for retirement, it sounds like she's not asking for spousal support. She instead wants to get, I think, payments from her ex's retirement, or maybe the actual retirement. She says, how do I feel? I think she says, she means, how do I fill that out, I think. Let's see, what comments do you have about this, Maria?
Yeah, so I think typically when it comes to getting spousal support or dealing with retirement accounts, normally the most common way to divide retirement accounts would be through a QDRO, Qualified Domestic Relations Order. And this form is also a way to get payments. So let me just backtrack. With a QDRO, the primary way to use a QDRO is to divide retirement accounts, especially if you're dealing with a divorce. Now you're dealing with property settlement issues, and there are retirement accounts. There's different kinds. I mean, it's a very extensive area, so I think you can do a whole lesson on QDROs in and of itself because there's so much to go into. But generally, with a QDRO, you can divide retirement accounts, and that's for the property settlement issue. But another way that sometimes is overlooked is you can also use a QDRO to get support, so spousal support, child support. So the video seems like it's mainly covering more of the support issue. So the form is useful for tapping into maybe retirement accounts and pulling from that as payment for the support, whether it's court-ordered for spousal support or child support. So that's one resource. But of course, if the question is dealing with retirement accounts, that's a separate process, again, through a QDRO. But you would need to have an order that allows for the retirement account to be divided. So I think it taps into kind of two different processes, all dealt with through a QDRO form or a process.
Yeah. So the person on this who made that comment, what you're going to want to do is if you go to the My Court Coach YouTube channel, you can either go to the playlists, or for you, what I would do is I'd go to this little magnifying glass to do a search. And if you do a search for QDRO, Qualified Domestic Relations Order, is that what QDRO stands for?
Yes.
So do a search for QDRO, and you're going to see that there's a video that we have on it regarding forms and see if that's helpful. The other thing you can do, rather than do a search for QDRO, is do a search for retirement. And here's a video that we have already, how to get money out of your ex's retirement fund regarding form FL370. So take a look at those forms. You're always going to want, if you have questions, go to the search bar of our YouTube channel and see if you can find a video. Chances are pretty good you'll find a video on the topic that you have a question about. What do you think, Maria?
Yeah, I think there's a lot of videos that cover many of these issues. So I think that would be the best way to kind of get clarity on the question, and maybe go through the video, see if there's still, whoever wrote the question, to see if maybe those videos answer the question that the individual had in mind. I think you have a lot of great videos on there that should answer the questions.
The other thing is QDROs are pretty specialized. There are family lawyers who do nothing but QDROs. That's how specialized they are. And so if you do a search for a QDRO attorney, you might get even more of your questions answered rather than just any old family lawyer. I know, at least in San Diego, I know there are a few that are very specialized in that. I think there are some that are like statewide. Do you know any who only do QDROs?
Yeah, I've run into attorneys that only do QDROs and attorneys that don't do QDROs at all. So if it comes to dividing retirement accounts, they defer it out, or they bring in these specialized attorneys to deal with only that issue.
Right. Okay, I think that answers that question. What do you think?
I think so.
All right, let's go to the next one here. So this other question came in response to our video, when should I bring a contempt action against my ex in California family court? And this commenter says, what if a parent disappears for months with no communication and misses his or her visitation? Can you bring contempt against the other person because that other person, the other partner, just doesn't show up?
Should I jump in with my thoughts? Okay. I think we would need to know more, right? So I think we only have a bit of the information where it does sound like the parent, well, first of all, it sounds like there would have been an order, right? Because you can't bring in contempt action unless there is an actual court order that specifies the terms. Both parties are aware of the terms. And then the question then becomes, well, was the violation, or is the person or party that you're claiming may be in contempt, were they able to comply? Was it intentional, or was it perhaps maybe kind of like a good faith violation in a way? So it sounds to me that possibly, I mean, without knowing more, without knowing the details and the history and kind of the context behind the question, if there's a court order and one or both parties aren't following it, for different reasons, which we can get into. Maybe some are more justified, or maybe there's just a way to not comply with it. And then there's other times where they're willfully and intentionally, purposefully not following the orders, which it sounds like that may be the case in this particular instance. So if there's an order, the party is intentionally not following it, refusing to comply, then it's possible that they may be able to bring a contempt action as long as there's evidence to support the willful violation and kind of show the severity of the violation. So it's possible, but it's hard to say with certainty without knowing more context behind the situation.
Yeah, it's interesting because usually you see people wanting to bring a contempt action when someone isn't allowing you to exercise your own visitation versus this person is saying the other party is not exercising their visitation and I want them to. Curious, what brought that on. I mean, it might be just because it's hard on the child or children. Or maybe because, they have to go to work and they can't go to work because the child isn't being picked up or, things like that.
Right. So it does matter why the order isn't being followed, right? Is it that they just could disregard it, they don't really necessarily care, or they're just intentionally wanting to do whatever it is that they want without following the terms of the order? Then maybe if it's egregious, but if it's, like you said, more of like a good faith violation, there's reasons where they can't necessarily follow the order or follow the terms of it, then that does come into play as well. And I think at that point, if, say, for example, if somebody did bring a contempt action, sometimes the courts will look at that. And if it needs to be modified, they may just modify the order if there's reasons that they couldn't comply with it, or if it's just simply not working. And it is more of a good faith reason why they simply can't comply, then it may justify some sort of modification so that both parties can follow it. But if it's just a complete disregard, then that does fall more into the line of a potential contempt action. But it sounds like this individual wants the other party to follow it and to enforce the visitations, maybe to try to get them on board, co-parent with them, have the child see the other parent. But sometimes you can't necessarily force a parent to be involved if perhaps they don't necessarily want to, or whatever the reasons may be.
Yeah, let's assume the parent, the person who was not exercising visitation, the person who violated the order, just doesn't want the visitation. It wasn't that the car broke down, or something like that, or, an emergency hospital visit, but just doesn't want visitation. You'd think, I don't know, different judges have different temperaments. But I could see a judge saying, well, rather than file contempt, let's just change the custody order. Like now you get more custody and now there's more, and now the person who doesn't want visitation is now paying more child support. And if, let's say it's the dad who doesn't want visitation and it's the mom who's posting this question about contempt. If the mom needs to get daycare because she has to go to work and when the dad's not doing visitation, then you could see the judge saying, well, let's just change the order rather than do a contempt.
Right.
I don't know. Can judges do that? If mom files contempt action, could judges say, well, let's fix this in another way?
I think so, because the contempt action is more punitive. You're basically just punishing the other parent for willfully violating the court order, not complying. But if, let's say, they want to still be in the child's life, they still want to parent and co-parent, then and maybe just the terms of this original order just simply aren't working, then a judge may be able to modify it and change the order so that they're more likely to comply with the new terms or match the situation where they can both be on the same page, where it's more likely that they'll follow it versus have the order remain and simply not be in the child's life.
Right. And the funny thing about, not the funny thing, but the thing to remember about contempt is it's a crime. And so you're bringing a criminal case. Normally only prosecutors, district attorney's offices or city attorney's offices can bring a criminal action against an individual. And this is a unique situation, contempt hearings in family court where an individual can bring a criminal action. And what that means, a criminal action is behavior that is punishable by jail time. It's punishable by fines too. The judge could find there to be contempt and just issue monetary sanctions, fines. But jail time is the other thing. And so if you're saying I want the dad to exercise visitation and he won't do it, therefore he should go to jail. I mean, if he's in jail, how is he going to exercise visitation? I'm not sure that really gets you the solution that you want.
Exactly.
Unless it's jail time for a day, on something like that. But on the other hand, I've seen judges can get in a predicament if in the leading up to this one violation, there were many other violations and like a load of warnings from the judge saying, hey, you better follow the order. If the judge doesn't go ahead and go forward with contempt, you could see how the judge might sort of lose some respect and lose some force behind his or her orders. Sort of like a parent who, threatens to do a spanking and doesn't spank, or threatens to sort of, discipline but doesn't follow through.
Right. And you bring a good point, because it's the repeated violations, which I think does kind of make it more severe. If the judges said, hey, comply, we've tried to enforce this, we've tried to get both parents to comply with the orders, but now there's just repeated violations and they're pretty egregious, then it is more likely that a judge may look at it and go ahead and want to sanction or impose fines, or possibly even set some jail time if it's egregious enough, if it's severe enough, that is possible.
Yeah. That sort of goes into the next question. This is a video, how many times can you file for contempt of court? And, you wouldn't probably want to file for contempt on the very first violation. But this person says, she has a question. Can I file contempt of court on my ex if we have joint legal and physical custody, and we have equal decision-making rights on important decisions, which means shared legal custody, and the father enrolls the child into a school without speaking, or getting agreement from me? What do you think about that?
Well, when parents share joint legal custody, they do have to confer with each other. They do have to make these decisions and talk to one another. You wouldn't necessarily be able to just do whatever you wanted without at least informing the other parent, without having some sort of discussion about it. Now, whether this is kind of going back to what we were talking about, if it's just this one incident where you just went ahead and enrolled the child without talking to the other parent, whether it rises to the level of contempt, again, if we look at it, fine, there's a court order, they're supposed to share legal custody, they're supposed to talk to one another, and one parent didn't. Or you can argue potentially that would be a violation, but again, does it rise to the level of contempt? Is this a good faith violation? Meaning, and we don't know, what if there was deadlines for when to enroll the child, or what if they've tried to talk about it but never really reached a decision, or who knows, right? We don't know the context behind what led to the other parent to just enroll the child, and if there ever were any sort of discussions or conversations around this at any point. Then if it's just a good faith violation, there's really no other incidences, they typically co-parent well together, let's say, then, judge may just look at that and not necessarily want to impose the highest, sanction, right? They may look at that and say, perhaps maybe it was just a good faith violation. He was supposed to, but didn't. That's one way to look at it. Now, would a judge want to look at this and think that it's a egregious violation, intentionally, willfully disregarding it? Maybe, but again, does it lean on the good faith side, or does it lean more to the complete disregard and not wanting to share legal custody together or work together at all? And if that's the case, then maybe, like we talked about, maybe they want to change the custody orders or the parenting plan. Maybe, an instance like this might warrant more of a modification versus punishing the parent for enrolling the child in a school.
Let's say it is bad faith. Let's say they talked beforehand and talked about two different elementary schools. Let's say one's a public school, one is a private school, and so it sounds like it's the mom. So the dad went ahead and enrolled someone, and let's say he enrolled a child into a private school. And they talked about it. And she says, no, I don't want to spend the money on it. And he goes, well, I think this is the best school, and he just does it on his own, which means it's going to be more expensive for both parties, mom and dad. And what do you do? I'm just thinking about how long. You wonder, okay, when do I file for contempt if you're going to do it? The child's been enrolled. What if the child is it the first week of school? Is it the second month of school? You can see how the judge might be. Does the judge just issue an order saying, nope, go back to public school right away? I don't know. Can you file for contempt and an RFO regarding these, school at the same time?
From my experience, it's usually better to pick one or the other because, again, the contempt mostly is more of a punishing or a punitive type of action. If you're trying to maybe enforce it or raise an issue or seek a modification, then you might get more headway that way. You might actually get the court to revisit the issue and see, is this working or not, and then make some changes versus just solely punishing the other parent for making kind of an executive decision or a unilateral decision without talking to the other parent. And these things happen all the time. I have seen it. I hear it quite often where parents go ahead and enroll, especially around the fall time when kids are going to be back in school. They make changes, they put them in different schools and whatnot. And yes, it does affect potentially the parenting plan, the visitation time. So those are things that I think could be revisited, potentially modified if it's just presenting a problem and you can't abide by the order as it is. But to solely use this to argue to the court that the other parent completely disregarded the joint legal custody order, it's hard to say. Personal opinion, I'm not sure if a judge would hold somebody in contempt, especially when it deals with the schooling of the child, because they are looking at, well, what is in the best interest of the child? Ideally, they want both parents to parent well together, co-parent, make decisions together. But again, we don't know the circumstances. We don't know all the details and the totality of the circumstances to say, is the school bad for the child? Did the dad make a decision that could potentially be detrimental? Who knows? But sometimes courts won't punish a parent for making a bad decision. I think they do look at, they allow leeway for parents to make decisions, and they won't necessarily punish them if the decision necessarily isn't the best one, right? Because parents have to make decisions all the time. We don't necessarily know if it's going to be, the best one, but sometimes, we parent anyways, we make decisions, and the court's not going to say this is a good decision or a bad decision unless it, of course, is detrimental to the child.
Yeah, and contempt actions, those aren't fast. Those aren't litigated quickly. So if you want your child to change schools, maybe bringing like an emergency order, an ex parte order, but a contempt action, that's going to take a while. The dad would have certain rights, just like a criminal defendant would in a criminal case. And so that's not likely to be litigated quickly if your goal is to have your kid enrolled in a different school, like ASAP. Contempt might not be the best action there.
I agree.
Okay, that is all the questions we were going to answer today. We thought we'd do a little live stream on your lunch hour. I hope this is helpful. Any other comments, Maria?
No, I noticed that we don't have any additional comments right now, but if any come in, I'm happy to answer them. Maybe we could do other live streams and talk about other issues that may come up or questions that may come up after this conversation.
Yeah, one thing I did want to show, I know I just recently showed it a moment ago, but I just want to encourage people to use this search bar. If you type in contempt in the search bar on the My Court Coach YouTube channel, you're going to see videos that I think will be helpful. What contempt of court means, full explanation, ex violating court orders, request a contempt hearing. And anyway, so these I think will be answering a lot of the questions that people will have. Okay, we're about a half an hour in. And I can't think of anything else to discuss for contempt of court. Anything else regarding contempt?
I think we covered it. I mean, we did talk about what is warranted or what the contempt action does, how it's for, how judges tend to look at it, whether it's warranted or not, and kind of, I think we covered the gist of it. But again, if anybody has questions, happy to cover it and talk more in depth if necessary.
Yep, we'll be answering comments to these videos. Just a reminder, My Court Coach is helpful for legal coaching. So head over there, take a look at our California Family Law course to get some extra downloadable content that you can bring with you in court. Check out our full court preps. If you're going to be presenting a case in court, if you're going to be bringing a contempt action and you need to present evidence such as like text messages or emails showing that whatever your communication was with the other party, you're going to want to make sure that the judge actually takes a look at those text messages. There are certain words that you need to use and you need to say when you're introducing exhibits in court. And so the full court preps will help you make sure that you get those text messages seen by the judge. I've seen it many times where a party wants the judge to look at evidence and the judge says, sorry, I can't look at it. You haven't presented it correctly. So the full court preps will give you scripts to use word for word. You can print it out, take it with you in court. You can hold the paper up and just read it to the judge and you'll be A-okay. So take a look at that. And that's all for now. We're going to be on another live stream soon. So if you have any questions, make sure you post comments so that we can bring it up in the next live stream. And Maria, thank you so much for joining me. I really appreciate your help and your advice to the viewers.
Thanks for having me. This was fun.
All right. Take care, everybody.
Bye.